Earlier this month, the mislabeled Employee Free Choice Act of 2009, S-560, was introduced in both houses of Congress. Free choice? Give me a break. We are living in a land of make-believe where our words have the opposite effect of their true meaning, much like Humpty Dumpty, who said that, quote, words mean only what I choose them to mean, neither more nor less, unquote. If properly labeled, the bill should be called the Employee No Choice Act or even the Employee Forced Coercion Act of 2009. What is the most radical overhaul of national labor policy in my 30 years in the United States Senate? EFCA is not just another bill that can be passed quietly outside the public eye or that can be, quote, compromised, unquote, with a few minor tweaks. It represents a sea change in labor management relations. EFCA would effectively deny workers a secret ballot vote on the question of union representation, and there is no choice for workers to make in the matter. Now, during the Help Committee hearing, Senator Harkin ridiculed business for describing the battle over EFCA as Armageddon. Well, it sure seems like Armageddon to me based on the bill's anti-democratic principles, the bill's monumental changes to more than 60 years of national labor policy, denying workers a private secret ballot in a democratic process on whether to be represented by a labor union, and compulsory outside interference by the federal government in setting terms and conditions of employment, and I might add even wages, for private sector workers and businesses. Now, with regard to compulsory first contract arbitration, what would occur if someone from the federal government came into a family-owned business, or any size business for that matter, and said, this is what you must pay your employees. These are the benefits you must provide. And by the way, you must become part of your industry's multi-employer pension plan that is badly underfunded, and you must accept your industry's pattern bargaining agreements. This is your work schedule and the hours you employees will work. These are your work rules. This is your disciplinary procedure. And oh, by the way, you may not subcontract work. Any new operations must be union. You must remain neutral in union organizing campaigns at other facilities, and you must check off dues for the union from employees' wages. Here's the big difference. Under EFCA, once the union organizer gets those sitting on the left side of the room to sign union authorization cards, and one more person is hoodwinked or otherwise coerced, or for any other reason signs a card in support of the union, the organizer does not have to ask those sitting on the right side even to sign a card. They are automatically in the union and a part of the bargaining unit, regardless of whether or not they were asked to sign cards or whether or not they even knew there was a union organizing drive. EFCA is simply wrong at the wrong time for this country. Economists tell us it would lead to higher unemployment at a time when we are already hemorrhaging jobs. Businesses large and small tell us that it will make them non-competitive and force them to close their doors or move overseas. The American public, in poll after poll, opposes EFCA. The Employee Free Choice Act is not just a bad bill for labor management relations, it's an economically devastating bill for the country.
There's really only one issue, and that is, what do employees want? If they want a union, they should be entitled to have a union. Equally, if they want to stay out of a union, they should be entitled to stay out of a union. And the question should be settled by a majority of the employees in a particular situation, voting in an informed and uncoerced circumstance. And each company is unique unto itself. Each company should be free, or the employees of each company should be free to make their own decisions. The thing that bothers me about this legislation is that it does not respond to the issue of what do employees want. Senator Hatch has already quoted the poll. 74% of union households do not want this legislation. So if we're going to respond to the basic issue of what do employees want, we're going to vote no and see that the legislation is defeated and thereby be true to the requests and desires of our constituents. Thank you, Mr. Chair.
Simply put, what we have in front of us is a bill that is unfair. It is a bill that unlevels the playing field, and it is a bill that overreaches. We don't need this in America today. We have stability between the employers and employees. That stability has been in place for a long time. It is governed by rules that have been in place for a long time, and those rules have been interpreted by court decisions. And that relationship between employers and employees, both groups of which are critical to the American economy, to our quality of life, and to our way of life, if that relationship is tipped one way or the other, it would be devastating to the American economy and to the American family.
This card check provision would, in effect, eliminate secret ballot elections. Supporters say they are proposing card check to stop intimidation in union elections. But the single best protection against intimidation in elections is the secret ballot. Union members would confront employees in the parking lot, at their homes, at the local hardware store. Perhaps they would surround them. They would hand them a pen and an authorization card and ask them for their support. In speaking about union elections, it's important to distinguish between employer coercion on the one hand and employer free speech on the other. American jobs are created by entrepreneurs who've invested their time and their own energies in starting, establishing, and operating those businesses. And those entrepreneurs, under the Constitution, have a right to speak to the voters who will decide whether they must now share their enterprises with a union instead of American business and the economy. As Senator Hatch, you said, one of the most basic principles of American labor law is that a company is required to bargain with a union in good faith, but it's not required to agree to any particular contract term. EFCA's arbitration provision would topple this pillar of American labor law. Companies and workers would be governed by so-called collective bargaining agreements that in fact are none of the above. They would not result from bargaining. They would not be agreements, they would be mandates, and they would not reflect the collective effort and view of the employees who would have no opportunity for a ratification vote. We should not turn the keys for managing American companies over to government appointees who themselves may not know the business and may have never run their own payroll.
In the time that I've spent working with Coakley, I've seen many cases of union intimidation, some aimed directly at me, writing on the walls, threats, and in the 1990s, and a vote came up, and there were guys coming in off the job from the unions, telling me, you know, watch your back and forget what you see, Mr. Cannon, because I was the foreman at the time. I just wanted my guys to go back to work. Even I felt threatened, much less the workers. They've come in to pretty much upset the balance that you have. There's a lot going on in jobs, and it's almost like it's purposely done to disrupt the progress of the job. And in most cases, you don't have the one guy all the time. We have one guy come to the job periodically. But this guy on this particular project was going around getting people to misleading them into signing this, thinking that they were signing, you know, safety. You know, hey, you forgot to sign in the register about fall protection or whatever, when it was really, in fact, signing up for this vote. They had made this straw dummy, straw and cloth and paper dummy of one of the foremen, and they had it hanging over the atrium. He was, you know, just a foreman doing his job, and they didn't like the way he did it, and he was scared to death. They also blew his car windows out. They beat up one of the foremen.
One legislative proposal we must avoid is the Employee Free Choice Act. This legislation proposes the most sweeping change in labor law in 70 years, since it is our opinion and that of the business we represent that this legislation would impose unfair and burdensome cost on businesses of all sizes. In the long run, both business owners and employees would suffer. If made law, this bill would boost costs, restrain productivity, and make businesses less competitive.
I appreciate the opportunity to stop by and briefly recognize my constituent from Lexington, Kentucky, Kathy Gornick, who is president of Thiel Audio and is here on behalf of the Consumer Electronics Association.
As a second-generation American woman, I know firsthand why Europeans left in droves, what they suffered, and how much better they fared here in the United States. And I would like to point out, anecdotally, that it is because of this document that my grandparents came here. I am profoundly grateful that America let me take my vision and transform it into a business. No other country or system is as friendly to entrepreneurs and risk takers. This bill allows government to unilaterally step in and set wages and working conditions if negotiations between the union and the employer become deadlocked. A tech firm must be innovative and nimble or it will not survive. Our work environment is fluid and flexible, with firms constantly adjusting product lines and job duties in response to new threats and opportunities. Now, imagine a technology company forced to operate under the auspices of card check. Within 120 days of a coerced union election, a government bureaucrat could unilaterally determine the most elemental working conditions for the entire workforce. A card check may grow the number of union members in this country, but it would not grow the number of jobs. One economic study projects that card check would add a full percentage point to our nation's unemployment rate. That's 1.6 million more Americans losing their jobs. As an entrepreneur and a proud American, I implore you to reject this ruinous proposal.
And I would simply note that it's referred to, as are many bills around here, they give them great titles: Employee Free Choice Act. I would argue it's the Employee No Choice Act. Even though it's being billed as something that's good for working people, I think it's very anti-worker. It deprives people in the workplace of an opportunity to cast a secret ballot in a union election. This is a job killer for our economy. It's something that would be absolutely disastrous, I think. And so I'm hoping that there will be enough people around this country who will rally to this issue, recognize the harm that it would do to the economy, and would help us get the votes in the United States Senate to defeat it. It's been argued, I should say, that minority workers would benefit from this legislation. I guess I'm just curious to know, based on your experience, do you believe that is a true statement?
Representing 3.5 million Hispanic small businesses, we think that this truly is, as you said, a job killer for our community in certain instances.
Idaho, the state I represent, is a right-to-work state. And we got there only after a lot of debate, a lot of serious soul-searching. A bill was passed in the legislature, it was vetoed, it was overridden. The unions then took it to a referendum, all of which gave the matter a very good airing. In the end, the voters, by a wide margin, agreed to the law that the legislature passed, and that is allowing a worker to either join or not join a union. After all this work that the state put in it, and after all the emaciations they went through, what effect will the bill, will this particular bill have on the 20-some states that are right-to-work states?
A guy I've gotten to know over the last several years, he was telling me about an organizing attempt at his company, and they got 30% of the employees to sign the cards, so they went through the process. And when it came to the secret ballot, they had about 100 employees working. Only one person voted to organize. And so he went to his employees and he said, "Why did you sign the cards?" And they said, "Well, you have no idea the intimidation that takes place. We signed the cards just to basically get them off our backs." But they obviously, based on their secret ballot, They thought that they were being treated well by their employer, and they didn't want to have a union represent them.
I think people ought to have a right to unionize, but our laws protect their rights in almost every way. I think every way. And in all honesty, to take away the secret ballot, and that isn't, to me, that's not the worst part of the bill. I think the worst part of the bill is mandatory arbitration, where they set the wages, terms, benefits, and conditions of employment.